surprise me.
Hi, I'm Attorney Iworski. How are you?
Good, how you doing?
Good. So I'm covering for Attorney DeCroce today. So you're scheduled for a sentencing hearing today on the disorderly conduct, and then you were scheduled for a trial on the breach of bail charge, right? Is that what you have as well? Okay. So what we're going to do today is we're just going to go forward with the sentencing hearing. I'm not going to go forward on the breach of bail. You were convicted on the disorderly conduct. I don't see a reason to pile additional charges onto you. So you'll be sentenced on the disorderly conduct, and then we'll be done today. Okay?
So you're dropping the breach of bail?
I am. Yep. Okay. And I spoke with the trooper about it, and he's fine with that.
There you go.
Okay.
Good. Thank you so much.
All right. Sound good?
Yeah, no problem.
All right.
All set?
Yep.
Okay.
Here's a cleaned-up, extended rewrite that removes insults and inappropriate language while keeping the message clear, firm, and easy to understand. Let's be clear about something. You do not have the right to show up at a government official's private home and harass them or their family. That kind of behavior crosses a serious line, especially when it escalates to the point where law enforcement has to get involved. Public disagreement does not justify personal intimidation. That is exactly what happened in this case. He, along with a group of protesters, went to a government official's residence and caused enough disruption that the police were called. This wasn't a misunderstanding or a peaceful demonstration. It was harassment directed at someone's home and family. As a result, he was convicted for his actions, and what we're watching now is the sentencing phase of that case. This hearing isn't about debating opinions anymore. It's about accountability and determining the consequences for behavior that the court has already ruled was unlawful.
Please listen.
Brief that, Frank.
Yeah, well, I mean, there's no way. I got the law right here, right? So, I didn't create danger, obviously, which is why this has been dropped, and I didn't commit a felony, okay? I'm being persecuted for exercising my First Amendment rights.
It's interesting how someone can appear calm and in control right up until the moment they are challenged or disagreed with. That sudden shift says a lot, and it doesn't point to a lack of control. It points to a lack of accountability. What's really on display here is an inability to handle opposing views without reacting emotionally. When disagreement is met with anger instead of reason, it weakens the argument rather than strengthening it. Confidence isn't shown by losing composure. It's shown by staying level-headed when things don't go your way. At the end of the day, reacting this way doesn't convince anyone or prove a point. It just highlights the problem and makes it harder to be taken seriously in any meaningful discussion.
Great. How come you're getting angry? Didn't you and I just didn't we just have
Because I'm here today for nothing. That's why I'm getting angry.
You're here for a sentencing hearing.
Yeah, I know. And I got found guilty of disorderly conduct for less than what I'm doing right now.
Okay.
For being loud. Because I have a loud voice. So I got found guilty of disorderly conduct for having a disability because I get excited and hyper-aggressive.
Alright, Frank, let's bring it back down a notch here. I know there are going to be plenty of people who criticize how the court responded to his disruptive behavior, and honestly, it wouldn't surprise anyone if the judge had chosen to hold him in contempt based on what we saw. That said, there's likely more going on behind the scenes. The court is probably very familiar with this individual and his history, which can play a role in how situations like this are handled. Sometimes the goal isn't to escalate things further, but to move the case along as efficiently as possible. Giving him some extra leeway may simply be the fastest way to get through the hearing without turning it into an even bigger spectacle. Still, it raises questions about balance and consistency. I'd really like to hear what you think. Was the court too lenient, or was this the right call under the circumstances? Let me know your thoughts in the comments.
And you had your day in court.
Oh, and I was found guilty, yeah. I had my day in court, and what was I found guilty of? Why am I not under arrest for disorderly conduct right now?
Sir.
Why am I not under... Hey, listen, don't give me no directives. You're just going to make it worse. Ridiculous.
Hey, Frank.
Absolutely ridiculous.
Frank, was the breach of bail when they arrested you here? Was that one, or was it a different one?
Judge is on the way.
Yes.
We'll wrap this up and you'll be on your way.
That was the one, thank you. That was the breach of bail for the New Hampshire 9 arrest. For where someone was arrested for saying amen. And I was arrested for, we don't know yet, making a loud noise. Which is all on video, and I didn't make one fucking peep. Not one fucking peep.
courthouse.
I don't care, it's not illegal to swear, okay?
If you
I don't need,
disturb
listen,
other
have me
people-
arrested, do something. Do something.
I don't want to.
Do something, because you can't.
I'm trying to
Don't
work with
give
you.
me directives and tell me what to do or what to say or anything.
Frank, come on, Frank.
All right, Frank, enough. You're complaining about her explaining to the judge why the remaining charges are being dropped, and this is simply not the moment for that kind of pushback. This part of the hearing isn't about debating or interrupting, it's about the court putting the record on file. When the judge is being informed of decisions like this, arguing only makes things worse. It doesn't help your case, and it doesn't change the outcome. This is one of those moments where staying quiet and letting the process move forward is the smartest option. Courtrooms run on order and timing. Speaking out of turn or challenging explanations at the wrong moment only shows a lack of judgment, and that never works in your favor.
I'm trying to, but these people, they all want to take their time. Oh, hey. Oh, just calm down, let it be cool. No, this is absolute bullshit why I'm here today. And everybody knows it, and that's why you dropped those charges.
I told you why.
So I get it, you're cool, you dropped the charges, I appreciate that. It's nothing personal against you.
Then be
This
cool
is
with me,
business.
like I'm being cool.
I am being as cool as I can be.
Frank.
Okay?
Come on, Frank.
You wanna get this done?
Oh, I'm ready. Let's do this thing. I've been here. Let's go.
The priest will enter.
All rise, honorable court is now in session.
All right, good morning, everyone. Thank you. Please be seated. All right, and this is State versus Frank Staples, docket number 435, 2021 CR 240, and dockets number 435, 2021 CR 1692. Attorney Iworski does appear on behalf of the Newfields Police Department. She's filling in this morning for Attorney DeCroce. Mr. Staples does appear. He is self-represented. We are scheduled this morning for a sentencing hearing in the 2021 CR 240 on the Class B disorderly, and then additionally, the matter is scheduled for trial in the breach of bail charge. Are we ready to proceed?
Judge, we're going to go forward on the sentencing order. As I told Mr. Staples, the state police are here. I had an opportunity to speak with them. Although we are ready for trial, I think in the interest of fairness and equity, he's been convicted of the underlying disorderly conduct charge, so we're going to use prosecutorial discretion.
How is it underlying when the breach of bail took place afterwards?
If charge after charge is being dropped, then ask yourself this: why are you sitting in a sentencing hearing right now? From both a logical and procedural standpoint, sentencing only happens after a conviction has already occurred. This stage of the process isn't about debating guilt anymore. That part is over. The court has already made its finding, and now it's focused on determining the appropriate consequences. That's how the legal timeline works. So arguing about dismissed charges at this point completely misses the mark. The case has moved past that phase, and the courtroom is now dealing with what comes next, not what's already been decided.
The breach of bail charge, and we're just going to go forward on the sentencing hearing with the disorderly
Okay,
conduct.
all right, very good. And then I will give you that one. Oh, wrong one. I gave you that one. This is the breach.
That's somebody different.
All right, thank you.
Thank you.
All right, so with that then, if we're ready, we'll proceed with the sentencing and the state's recommendations. Mr. Staples, what I'm going to do is I'm going to hear from the state first, what they're recommending relative to the disorderly conduct, which was a Class B misdemeanor in that matter. And then after I hear from them, I'm certainly going to hear from you as to any recommendations or any position you take as to penalties, okay? So with that, thank you, Attorney Jaworski.
Judge, the state's going to ask for a $1,000 fine, 500 of that to be suspended for 2 years of good behavior. Your Honor heard the facts and circumstances of this case. similar charges to this recently.
That get dropped and dropped and
Okay,
dropped.
all right.
I don't think mentioning that one incident from when you were 17 is going to change the bigger picture here. The court isn't focused on a single mistake from your teenage years. It's looking at a clear pattern of behavior that has continued well into adulthood. What matters is the repeated conduct over time. Since becoming an adult, there have been ongoing choices that show a consistent disregard for the law and for social boundaries. That history carries far more weight than one old incident. Courts look for patterns, not excuses. And when someone repeatedly makes the same kinds of decisions, it becomes hard to argue that those outcomes are accidental or unfair.
Interrupt them.
Prior conviction for bail jumping in 2013, on February 11th of 2013. It looks like he had 1 to 7 years for a sentence with counseling, mental health treatment. He had a possession of prescription drugs also in 2013 where he was convicted. He had multiple counts. He received a 12 months time served sentence in that particular matter. He had a possession of a controlled drug with intent to sell conviction in, looks like 2004 out of Hillsborough.
When is my sentence over? When is the crime done?
Okay, Mr. Staples, please, I'm gonna hear from you also.
Yeah.
But she gets to recount what she
Fine.
wants,
She
so,
can do whatever she wants.
thank you.
Another possession of controlled drug with a 9-month sentence. Shoplifting conviction in 97.
I was 17!
Mr.
A juvenile!
Mr. Staples,
So she's bringing up my juvenile record then?
What we just heard was only the first portion of his criminal history, covering convictions from 1997 through 2013. And that wasn't even the full record. There are still several more pages of documented offenses left to review. That alone says a lot about the pattern the court is looking at. At some point, repeated chances stop being opportunities and start becoming warnings that are being ignored. This isn't about one mistake or a short, rough period. It's about decades of continued behavior that hasn't changed despite prior consequences. When the record is that long and that consistent, it becomes very difficult to argue for yet another fresh start. The court isn't just judging a single moment, it's weighing a long history and deciding what needs to happen going forward.
I mean, come on! What's really going on here?
Staples, do I need to take a break? Let's just get through,
Let's get through it then!
telling me what she wants to recommend and about your
And
prior-
why? Because of all these past crimes all the way back to when I was 17?
All
Get
right.
the fuck out of
Stop.
here.
And please with the language. Attorney Jaworski.
Judge, he has a robbery conviction in 97 out of Hillsborough South with a 12-month suspended sentence. That's the first half of his criminal record. He does have an additional 6 pages, but I won't go through every detail with the court.
Alright, Frank, let's be realistic here. The court isn't going to issue a fine based on personal jabs or exaggerations. Decisions like that are grounded in law, guidelines, and the facts of the case, not emotional reactions or commentary. Judges focus on what's legally appropriate and proportionate, not on insults or side remarks. Making comments like that doesn't influence the outcome and doesn't help your position in any meaningful way. In situations like this, the smartest move is to stay focused on the actual issues before the court. Anything else just distracts from the reality of what's being decided.
That's the reason why I am asking for a little bit of an enhanced fine, although I am asking that half of it be suspended for 2 years good behavior. Also, part of that good behavior is that
Not paying shit. Believe that.
we get,
Mr. Staples.
make sure we have the address. They would not be allowed to respond to that same address with a disorderly conduct charge.
Okay, Mr. Staples, you've heard the recommendation of a $1,000 fine with 500 of it suspended. Do you wish to be heard on what you're asking the court to impose within the limits of the maximum amount?
Yeah.
$1,200 fine.
$0.
No, she doesn't need to prove anything further at this point. You were already found guilty of the offense, and that part of the case is finished. This hearing isn't about determining whether you committed the crime, it's about deciding the consequences. This is the sentencing phase, where the court looks at the facts, your history, and the law to determine what penalties apply. Guilt has already been established, so arguments about innocence or evidence are no longer relevant here. Now the focus is on accountability. The judge is deciding what this conviction means in practical terms, including fines, conditions, or other penalties. That's the purpose of this stage, and that's why the court is here today.
Because I didn't do anything to cause any sort of pecuniary loss or any damage or anything like that. And I also am asking you to reconsider your finding of guilty, because I will be appealing this. I'll put you on notice, and I do want to know exactly what did I do to commit disorderly conduct, because it was nothing even like what I've been here today in this courtroom. Okay? I didn't do anything that was disorderly. I asked why I was being threatened to be arrested. The man never asked me to leave the area. You've seen the video. He lied in his testimony. So I want to know why I was found guilty to begin with. What? You need to articulate yourself.
Oh, make no mistake, he's going to be paying one way or another. The court isn't letting this slide, and the financial consequences are very real. Whether it comes directly out of his pocket or through enforced collection, the responsibility is his. Some people might wonder why the judge doesn't immediately send him to jail instead. That's a fair question, and it often comes down to legal procedure. In many cases, courts are required to first give someone the opportunity to pay fines or comply with financial penalties before imposing a harsher punishment. If payment isn't made, then the situation can escalate quickly. At that point, non-compliance becomes a separate issue, and the court may step in with more serious consequences. So this isn't leniency, it's the legal process giving one last chance before things get much worse.
You've heard on the sentence, we've had your opportunity.
$0! No penalty whatsoever!
Okay, thank you. And I've heard your testimony and listened for several hours at the trial, and I've issued that, and certainly you do have the right to appeal, and I will expect you to do that. So with that, I will adopt the state's recommendation. I will impose a fine of $1,000. $500 of that will be suspended for a period of 2 years for your good behavior.
Put me in jail now then, $50 a day. Let's go. $50 a day in jail because I ain't paying shit.
It's 150 now.
So
150, whatever. We do $10 a day. Let's do it.
don't sell yourself short. Are you able to pay the $500 fine? I'm sorry, yeah, $500.
I ain't paying no $500 fine. You gotta be kidding me.
So you know there's an additional time payment fee of $25 that gets added?
Don't care. I ain't paying none of it.
Okay.
Ever.
Oh, so you can be respectful after all. You know, Frank, a lot of the problems you keep running into might not exist if you spoke to people the same way you just spoke to the judge a moment ago. Those last few seconds showed that you're capable of being calm, polite, and reasonable when you choose to be. That kind of behavior goes a long way, especially in serious situations like this. How you communicate matters more than you seem to realize. Treating others with basic respect doesn't just make interactions smoother, it can genuinely change how situations turn out.
And so if I put you down, that it'll be paid in full within 30 days, in addition to...
Say whatever you want to say.
That's what I'll do.
Okay? Ain't gonna happen.
We'll be in recess. Thank you. Good
Yeah.
luck to you, Mr. Staples.
Thank you. Have a good day.
Frank, you are probably the last person who should be trying to guide others through recovery or reintegration into society. Helping people rebuild their lives requires stability, self-awareness, and the ability to function well within social norms. When it's clear that you're still struggling to manage your own behavior and interactions, it becomes hard to credibly support others facing even bigger challenges. Reintegration isn't just about good intentions, it's about consistently demonstrating responsibility and respect. Before taking on the role of helping others, it might be worth focusing on getting your own footing first. Leading by example matters, and without that foundation, the message tends to fall flat.
Bunch of bullshit.
Probably had a bad day.
Huh?
Wish him a bad day.
You better, yeah.
Amazing. You told her you weren't going to pay, and she's like, well, we'll put you on a time payment.
We'll put you on a time. Put me in jail now!
They don't want to put you in jail.
Let's go.
Put me in jail now! 5 years in solitary confinement, you get fucking fined, $500 fucking fine, get the fuck out of here.
I love how they brought
Unbelievable, you bring up all that fucking record too. I've changed my life. I have a fucking business where I help people reintegrate from prison and from rehab and from homelessness.
Real forgiveness and trust usually start once someone stops committing new offenses and lets go of beliefs that encourage antisocial behavior. Change isn't about words or promises, it's about consistent actions over time that show growth and accountability. People are far more willing to move past old mistakes when they see genuine effort to do better. That means following the law, respecting others, and taking responsibility without excuses. Until that happens, it's hard to expect understanding or acceptance. At the end of the day, rebuilding credibility takes patience and real change. Forgiveness isn't automatic, it's earned through behavior that proves someone is serious about turning things around.
When are my past crimes done with? When do I lay it down? Ever?
You already know the answer to that, Frank.
Never.
Never.
Right?
Let's go. Come on.
We feel it's running around. Bunch of bullshit. Hope you feel real good about yourself.
I don't think I've ever heard of anybody paying fines, any activists. It's funny, they think they get us and they don't.
Let's do it. I love this game. We could play this all goddamn day.
They just want to bring him back in for another hearing.
Yeah.
That's what they want.
Yeah.
Waste his time.
And seriously, why would the court want to bring this belligerent individual back into the courtroom when everyone would be better off if he just paid his $500 fine and moved on? That seems like the simplest way to wrap things up. The catch is, he still has to go 2 full years without committing another offense, or he'll owe the remaining $500. Given his history, it's hard to imagine him going even 2 months without running into trouble, let alone 2 years. Alright, that wraps up today's video. If you enjoyed it, go ahead and hit the like button. If not, hit dislike. Either way, leave a comment down below and make sure to subscribe if you haven't already so you don't miss any future content.